Welcome to the law offices of Chris M. Ingram's Immigration News Show. Today we ask, can algorithms judge your visa? We would like to thank attorney Chris M. Ingram and staff at the law offices of Chris M. Ingram for their hard work in preparing the research for this show, which draws on a wide variety of news sources from both sides of the aisle, providing a balanced view. Attorney Ingram is also a vocal advocate for the rights and protection of immigration applicants, although our coverage is designed to be nonpartisan. Please don't forget to like, follow, and subscribe to our channel. We are also on Spotify, YouTube, LinkedIn, Facebook, X, Reddit, and Instagram, where we're growing rapidly thanks to our social media team. You can also visit our website on www.breakthroughUSA.com. We'd love to see you there. Disclaimer. Please note that this presentation should not be intended as legal advice for your specific situation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughUSA.com and schedule an appointment. We'd love to hear from you and help you if we can. We'd also like to point out that this presentation was created using AI hosts. Okay, let's dive in. We are launching a deep dive today into the STEM immigration pipeline. And this is a system that, has traditionally run on this incredible mix of massive ambition, the promise of opportunity, and the free flow of global knowledge.
It really has. For decades, the United States has just been this magnet.
The ultimate magnet, yeah.
Pulling in the world's sharpest scientists, engineers, researchers, you name it. They all converge here, and that convergence is what has fueled just unparalleled innovation.
And economic progress.
Yeah.
But that engine, it's not self-sustaining, is it?
Not at all. And that engine of innovation, it still requires constant tending.
Mm-hmm.
But the whole environment around it has fundamentally changed.
How so?
Well, the ambition you mentioned, that's still there. The global talent is as driven as ever, but the actual legal structures, the regulations that support that talent getting here and staying here, they're under immense, almost tectonic strain.
Tectonic strain, that's a strong way to put it.
I think it's accurate. The experience for a STEM professional today, it's less like following a stable, clear path and more like navigating a dynamic maze.
Mm-hmm.
The rules around your work visa, your security clearance, your long-term status, they can shift so suddenly, often with very little warning, and that impacts every single stage of a career you might be trying to build.
So that dynamic maze, that's exactly what we need to unpack today. Our researchers, they've pulled together this extensive collection of legal research and studies, and it seems to highlight that we're in a real moment of transition.
A critical one.
And it seems to be defined by four critical pillars of change that really shape the reality for anyone in that STEM pipeline.
That's right. So first, we've got the new baseline reality of the digital footprint.
Okay, the digital footprint.
Yeah. This is the increasing reliance on algorithms and what's called continuous vetting. It means that years of your social media history are now being incorporated directly into visa decisions.
Wow. Okay, that's a big one. What's number two?
The second is the fundamental two-phase overhaul of the H-1B program. This is, a huge deal. It's driven by this dual push for modernizing job categories on one hand, and on the other, these really strong demands for integrity and anti-fraud measures.
Right. And the third pillar, this one sounds like it's maybe the most stress-inducing for a lot of people in the system?
I would say so. It's the profound and frankly destabilizing uncertainty surrounding the foundational OPT and STEM OPT programs.
This is that bridge from study to work.
It is the bridge.
Yeah.
And that pathway is now facing a significant pending regulatory threat that could fundamentally shorten the runway for global graduates, or even remove it entirely.
And the fourth pillar.
The fourth is the constant, the thing that hasn't changed and the thing we have to always keep in focus, the unwavering drive of resilient global talent.
The human factor.
Exactly. It's the constant determination of these professionals to solve the world's problems, even when the U.S. policy landscape itself becomes the first complex problem they have to solve.
So the bottom line for you, our listener, is that this isn't some peripheral topic that HR deals with for you once every few years anymore.
No, not at all.
It's woven into the fabric of every critical professional choice you have to make. Which research lab to join, which employer you can really commit to for the long term, and what risks you take just by sharing your professional opinions online. So our mission today is to provide that comprehensive analysis, that clarity you need to navigate this intensely complex environment and to do it proactively. Before we really get into dissecting the mechanics of policy and digital vetting, I think it's important to ground this discussion in the human side of things.
Absolutely.
To remember why this talent flow matters so much. And our legal research provided this incredibly powerful example, the story of the Nobel laureate Katalin Karikó.
Her story is just. It's truly remarkable. It's a powerful reminder of the kind of perseverance it takes to achieve a breakthrough, especially when you're navigating really unconventional scientific territory.
So tell us a bit about her background. Where did she come from?
She was born in 1955 in a small town in Hungary, Szolnok. Her family was of modest means. Her father was a butcher, her mother a bookkeeper.
Wow.
But her determination to be a scientist, that was clear from very early on. She got her PhD in biochemistry back in 1982.
And her journey to the U.S. in '85, that story is defined by just incredible risk, isn't it?
A huge risk. She immigrated for a postdoctoral fellowship at Temple University in Philadelphia. But the financial detail here, it's just crucial to understanding the stakes.
What was that?
She and her husband arrived with almost nothing. They had to sow their entire life savings, it was roughly 900 pounds, into their toddler daughter's teddy bear.
Into a teddy bear?
Into a teddy bear. It was the only way to get around the strict currency restrictions that the Hungarian government had in place at the time.
That single act, I mean, that speaks volumes about desperation, but also just incredible ambition.
It really does.
Yeah.
And once she was in the U.S., she focused her research at places like the University of Pennsylvania on messenger RNA, or mRNA.
And our legal team really emphasizes that at the time, this was anything but a sure bet.
Oh, not at all. The scientific community, by and large, saw mRNA research as highly speculative. It was seen as too fragile, easily degraded, and just too unconventional to produce any reliable results.
So she wasn't just facing skepticism from her peers. She was facing real systemic failure and professional setbacks.
Intense setbacks. She had repeated rejections for federal funding. Her lab's progress was derailed by budget cuts. She was under significant institutional pressure to just drop it and shift to more conventional research.
And she was even demoted at one point, right?
She was demoted because her groundbreaking high-risk work wasn't delivering the kind of immediate fundable results her institution was demanding. But despite all of that, the key variable that our researchers noted is that she did not leave.
She stuck it out.
She persisted. She stayed in the U.S. research system, trusting the long-term potential of her science.
And then came the breakthrough moment, the one that changed the world. It was in 2005 through a collaboration with an immunologist, Drew Weissman. What exactly did that collaboration solve?
They solved the two biggest technical hurdles that were stopping mRNA from becoming a viable medical technology.
Okay.
So first, they figured out how to use something called nucleoside modification. Essentially, they chemically altered the mRNA molecule so that it became invisible to the body's immune system.
So it wouldn't trigger a massive inflammatory response.
Exactly, which is a huge problem. And second, they perfected the delivery system, these tiny fat bubbles called lipid nanoparticles that could package and safely deliver that fragile mRNA payload into human cells.
That partnership, it really provided the blueprint for a medical revolution that most of us wouldn't even recognize until 15 years later.
Precisely. When the COVID-19 pandemic hit in 2020, 2021, it was the technology that Karikó had pioneered and perfected for decades that formed the backbone of the rapid response mRNA vaccines.
From BioNTech, Pfizer, and Moderna?
The very same. So decades of sustained perseverance inside the U.S. research infrastructure led to millions of lives being saved. And ultimately, to her recognition with the Nobel Prize in Physiology or Medicine on October 2nd, 2023.
And this isn't just a one-off story, is it? It really highlights a much broader structural reality.
It does. Our legal team points out that immigrant scientists have won more than a third of all U.S. science Nobel Prizes.
More than a third?
Yeah. They are central drivers of foundational breakthroughs, new patents, and the creation of high-growth startups.
So the lesson here is bigger than just one person's incredible story. It's infrastructural.
It's absolutely infrastructural.
Yeah.
Karikó's success, yes, it depended on her getting that initial visa.
Yeah.
But far more critically, it relied on the U.S. system's ability to sustain her, to provide access to advanced labs, to offer enduring institutional integration, and to allow her the space to do that high-risk research, even when funding was precarious.
So attracting global talent is only half the battle.
It's not even half. Retaining it and providing that stable platform for deep, long-term contribution, that's the greater challenge.
I think attorney Chris Ingram put it perfectly. He said, Katalin's story reminds us that possibility is not accidental. It is built. Immigration is not just about entry, it's about contribution.
That's a powerful way to frame it.
And I think that sentiment should really inform our perspective as we now delve into the complex and often arbitrary policy landscape that talent has to navigate today.
Rome, 20,000 spectators, one epic battle, two warriors, one destiny. But before they can fight for glory, they must face the real challenge, getting their visa approved.
If you want to enter, show me your visa.
They should have went to the law offices of Chris M. Ingram. They are very good.
Yes, I've heard the same. They handled my visa in no time.
Off to the lion's pit.
Come with me, boys. It's dinner time.
Because even legends need the offices of Chris M. Ingram.
Are you looking for a visa? Why don't you get your free consultation on the Breakthrough website? We're with you every step of the way.
Okay, so let's move from that history of persistence to the complex reality of the present. Today, when a STEM professional applies for a visa or even tries to maintain a green card, the government's review involves so much more than just transcripts or patents.
So much more. It now involves years of your digital history, and it's often being scrutinized by automated systems.
That's the core change, isn't it?
It is. The U.S. government has rapidly shifted its posture. It's moved from, some limited experiments with online data to building a formal, scalable infrastructure for using social media data in these really high-stakes immigration decisions.
And there was a specific moment, a watershed moment for this change.
There was. You can point directly to 2019.
So what happened in 2019 that changed the game so fundamentally?
The U.S. Department of State updated Forms DS-160 and DS-260, and these are the cornerstone applications for nearly all immigrant and non-immigrant visas. The ones basically everyone has to fill out at some point.
Exactly. And the update mandated that applicants provide their social media identifiers, their handles, that they've used over the prior 5 years.
5 years? That's a long time.
It's a huge chunk of your digital life. And this policy change, it affects an estimated 15 million visa applicants worldwide every single year. It formalized this mass collection of digital data.
And the stated goals were what? National security?
Stated goals were national security and identity confirmation.
But this data collection, it didn't just stay with the State Department, did it? Our team's research indicates this trend just exploded within the Department of Homeland Security.
It did. USCIS, CBP, ICE, all the DHS agencies have scaled up their use of social media in their screening and enforcement efforts.
And the crucial element here must be the automation. You can't have people manually checking millions of accounts.
Right, you can't. And that's the key. We're not talking about manual searches. Internal privacy assessments that our team reviewed cite a proprietary USCIS platform called ATLS.
ATLS. Okay, can you give us some more detail on how a tool like ATLS actually functions? What kind of power does an algorithm have in this process?
Well, ATLS is an automated rule-based screening tool. Its job is to ingest all those social media identifiers and other digital metadata that's collected during the application. Then it runs that data against specific, predefined sets of rules, the algorithms, to perform an initial risk assessment.
So it's looking for red flags?
It's looking for red flags. It might flag keyword combinations, specific affiliations you have online, or patterns of interaction that trigger an automated alert. So the tool is performing a preliminary, non-human judgment. It's triaging cases that a human adjudicator then has to investigate further.
The goal is speed and scale, but the risk is losing all context.
That's the trade-off. And this feeds into an even broader and I'd say more intrusive concept of continuous vetting.
Continuous vetting, that sounds like it goes way beyond just a check when you apply.
It does. Continuous vetting is designed to completely eliminate the idea that your legal status is static. Once you're approved, you're done. That's over.
Wow.
Systems are being designed to constantly monitor or rescreen legal visa holders as new digital data streams become available. Our researchers looked at a 2025 expert brief describing the government's intention to review all 55 million people with valid visas to visit, live in, or work in the United States for potential violations.
25 million people, that's a profound shift in the legal relationship between the government and visa holders. It's ongoing digital surveillance.
It is. And the standards being applied in this screening are also broadening. They're moving beyond simple security checks and into the arena of ideological scrutiny.
This is where the civil liberties concerns must really come to the forefront.
This is where it gets really complicated. In policy shifts announced in April 2025, USCIS said it would start screening for specific types of anti-Semitic activity for green card applicants and others seeking discretionary benefits. And beyond that, internal State Department cables have directed their consular officers to scrutinize student visa applicants' social media for what they call anti-Semitic viewpoints or any perceived hostility toward U.S. institutions.
But wait, how does an automated system, or even a human adjudicator for that matter, distinguish between legitimate political speech that might be critical of a foreign government's policies and actual hostility or anti-Semitic viewpoints? The lines there seem incredibly blurry.
That is the core legal and operational dilemma. In groups like EPIC and the Brennan Center, they argue that using this kind of broad social media screening for such subjective concepts is not only highly prone to error, but it also risks violating fundamental principles of free speech.
I see.
They point out that screening for political opinions, it lacks any clear evidence of utility for national security, but it imposes these massive social costs by revealing really sensitive information, your politics, your religion, your sexual orientation, things that should not be a factor in whether you get a visa.
And the practical result of all this is what's known as the chilling effect, a fear that just leads to professional and academic silence.
Precisely. I mean, think about it. If you're a highly skilled professional and you need to engage globally, maybe you're discussing complex political issues in your home country, or you're criticizing a U.S. policy in an academic forum, the knowledge that an automated system might flag your post, and that could lead to a visa denial or a green card delay, that creates enormous pressure to just self-censor.
So lawful speech, satire, even activism can just be stripped of its context by a simple keyword search and misinterpreted.
Easily. And this is particularly acute for the STEM community. They thrive on open international communication.
Right. STEM communities, they live on platforms like scientific Twitter or GitHub or these open source project threads.
They do. And those spaces are fast-moving, they're often multilingual, and they rely so heavily on complex technical jargon, inside jokes, international context.
Things an algorithm would have zero chance of understanding.
Zero chance. Automated tools struggle immensely to parse sarcasm, irony, or the nuanced meaning in these multilingual exchanges. Yet these imperfect signals are now being fed into these high-stakes systems that determine whether a researcher can stay in the country. It puts this intense burden on you, the applicant, to manage a digital footprint you've been building for a decade.
So how does a person manage this new digital reality while trying to maintain their professional integrity? It feels like a tightrope walk.
It is. It requires a really strategic balance between awareness and principle. And I think Attorney Chris Ingram's advice here is very practical. He says, if you are building a life in the United States, assume that your digital footprint travels with you. Be intentional about your online presence.
Okay, that's the awareness part.
Right. But then he adds, but don't let fear silence your voice or erase your achievements. The real answer is not to shrink back, but to insist that immigration screening be smart, lawful, and grounded in respect for human dignity.
So it's about being smart but not silent. All right, let's shift gears now. We've talked about the vetting, but let's talk about the actual mechanism of high-skilled work authorization, the H-1B visa. This is the primary bridge for millions of STEM professionals who are trying to transition into long-term U.S. careers.
Right. And this system has just gone through a really comprehensive two-phase modernization effort. And it's aimed at both improving integrity and adding flexibility.
And the need for modernization was critical, wasn't it? Primarily because of the fraud that had really started to erode confidence in the whole lottery system.
Widespread fraud. It was a huge problem. So the first phase, which was introduced in February 2024, it directly addressed this by implementing what's called the beneficiary-centric lottery.
Okay, beneficiary-centric. We know the old system was being gamed by some consultancies filing dozens of registrations for the same person. How exactly did this new system shut that down?
It fundamentally changed the unit of selection. So previously, the lottery was based on the registration. An employer files a registration, that's one entry.
Right, so more registrations, more chances.
Exactly. Now, the unit is the individual beneficiary, the person. USCIS uses the unique identifier of the individual, and they now mandate that you provide the valid passport or travel document number to group all registrations submitted on their behalf.
Ah, I see.
So it ensures that regardless of whether one employer or 10 employers register you, the person, get only one entry into that random selection pool.
And did this anti-fraud measure actually work? Did it curb that explosive growth in applications we'd been seeing?
It had an immediate and a very measurable effect.
Yeah.
And it really confirmed the scale of the abuse that was happening before.
What did the data show?
USCIS data showed a steep decline in the total number of registrations for the FY 2025 and FY 2026 cap periods. Our legal team noted that the number of submissions dropped by up to 27% from the previous year's just astronomical figure.
27%, wow.
Yeah. And policy analysts are very confident this drop is directly attributable to the elimination of that multiple filing strategy.
Yeah.
The system is just significantly fairer now. It levels the playing field for legitimate employers.
Okay, so that brings us to the second broader phase of reform, the big modernization rule that took effect in January 2025. What was the central element there that was aimed at improving efficiency for STEM roles?
I think the key improvement was refining the definition of a specialty occupation.
Okay.
The new rule clarifies that the required degree field must be directly related to the job duties. And this was a direct response to years of just wild inconsistency in how adjudicators were treating interdisciplinary roles.
Can you expand on that? What was the practical problem that this new wording solves for, say, a modern tech professional?
Well, the old rigidity, it caused massive problems for emerging fields. I mean, think about a data scientist who has a degree in statistics and philosophy.
Or an engineer whose degree is in industrial management, but they're working on AI for supply chains.
Perfect example.
Feeling lost in a maze of visa types and paperwork? Don't know where to turn? We've got your back. With clear answers and real help, we'll guide you every step of the way. Let's navigate it together. Your journey starts today.
Hello, you must be Clara. Welcome to the law office of Chris M. Ingram.
Finally, I found a law firm that will help me achieve my American dream.
At this law firm, you are important to us. That's why we will be with you every step of the way. So join us at the office of Chris M. Ingram.
Previously, adjudicators would often issue these requests for evidence RFEs demanding an exact degree title match.
Yeah.
That forced employers into these lengthy, expensive legal rebuttals.
And the directly related language changes that.
It gives USCIS the flexibility to finally acknowledge that modern tech jobs don't fit neatly into these outdated academic silos. Our legal team notes this change gives adjudicators the room they need to recognize that degrees in adjacent or complementary fields, like math, stats, applied physics, can satisfy the requirement for a specialty occupation in a field like machine learning.
So it should significantly reduce that high RFE rate that was plaguing those kinds of roles.
It absolutely should.
And beyond just the job definitions, the role also provided some really crucial flexibility for people transitioning from F1 student status. Tell us about the expanded cap gap protection. This seems like it provides a massive dose of peace of mind.
Oh, it's a huge relief for so many people. The cap gap has been notorious for forcing high-skilled workers into employment gaps or even out of status if their OPT expired before their H-1B was approved and activated.
Right, that dangerous period between statuses.
Exactly. And the old protection was often just not long enough. Under the new rule, the automatic extension of your F1 status and your work authorization can now run as far as April 1st of the relevant fiscal year, while your change of status to H-1B is still pending.
So let me get this straight. If I'm an F1 student, my OPT expires in, say, July, and I've been selected for an H-1B, my work authorization is now potentially protected all the way until April 1st of the next year.
That's right. In real terms, that means up to 9 months of employment certainty. It dramatically reduces the risk of having to stop work on October 1st and protects you against status violations during that long adjudication process. It's a critical buffer.
It lets employers keep their talent continuously.
Which is essential for projects that just cannot afford staffing disruptions.
And what about the new pathway for entrepreneurs? That seems like a major win for STEM innovators who want to build their own companies here.
Absolutely. The rule explicitly carved out a path for certain entrepreneurs who actually own an interest in the startup that's petitioning for them.
Because historically, that ownership created a conflict, right? It was hard to prove that employer-employee relationship.
It was almost impossible.
Yeah.
But the new conditions, they allow a founder to potentially qualify. It opens the doors for foreign-born talent to start and scale U.S. companies while maintaining their own status. That's a huge boon for innovation and job creation.
But with all this modernization and flexibility, it seems like the integrity measures are also being simultaneously strengthened. What are the key compliance elements that employers now have to really rigorously follow?
There are a few big ones. The rule codifies that you must have a bona fide, non-speculative specialty occupation position available as of the H-1B start date.
So no maybe jobs.
No maybe jobs. If the job is tied to funding that hasn't come through yet or a client contract that hasn't been signed, the petition is at risk. Also, DHS's authority to conduct site visits, either randomly or targeted, to verify compliance is now formally in the regulations.
And for consultants who are working at client sites, the scrutiny has increased there too.
Yes. The rule clarifies that the job requirements must be met at the actual location where the work is happening, the end client site. And it's those requirements, not just the generalized claims of the staffing company, that are what matter most in the specialty occupation analysis.
So it forces more transparency all the way down the employment chain.
That's the goal.
The message here seems to be that the H-1B system is demanding a higher level of honesty and compliance, but in return, it's offering greater flexibility for genuine, modern STEM roles.
I think that's a perfect summary. The system is simultaneously fairer and more demanding. And it reminds me of what attorney Chris Ingram says. Rules come and go, but one thing has not changed. The U.S. still runs on STEM talent. Your best strategy is to understand the system, document your value, and keep moving forward.
Okay, we've saved the most potentially disruptive topic for last. We've talked about the importance of the H-1B as a bridge, but that bridge itself rests on the foundation of the OPT and STEM OPT programs. And now we have to address the serious threat signal regarding the possible elimination or at least major restriction of this absolutely critical pathway.
And it is absolutely critical. The Optional Practical Training Program, or OPT, it's the single most important mechanism connecting U.S. universities to the U.S. workforce for international graduates, period.
So just to recap, standard OPT gives you 12 months of work experience.
Right. And then the STEM extension adds another 24 to 36 months on top of that. That creates this crucial window, often up to 3 years. And that window is essential, not just for getting professional experience, but for giving graduates multiple chances to be selected in that H-1B lottery while staying employed.
And the scale of this program just shows how important it is. Our researchers cited DHS data showing 122,101 students were participating in STEM OPT in 2023 alone.
It's massive. And if this program is curtailed, the consequences will be immediate and far-reaching.
It'd be systemic.
Completely systemic. The alarm bells really started ringing in late 2025. That's when DHS formally signaled that a regulatory proposal was coming to significantly restrict or potentially even eliminate the OPT program, including the STEM extension.
And what were the stated objectives for such a drastic move?
The stated goals were to curb perceived fraud, to ensure the training aligns more strictly with educational goals, and to address concerns, which are often raised by critics, about the program's impact on U.S. workers.
Let's break down those consequences, starting with student behavior. If that OPT runway is drastically shortened, what happens to global enrollment in U.S. universities?
Student choices would shift, and they would shift dramatically toward our competitors. Universities, as cited in the legal research we have, are warning that if post-graduation work authorization is cut to just 12 months, global students will just choose to bypass the U.S. entirely.
They're rational consumers.
They're highly rational consumers of higher education, and they're going to select countries like Canada, which offers these robust, multi-year stay-back programs, or European nations with clearer paths to residency that provide a more predictable return on their massive educational investment.
So restricting OPT is essentially an immediate surrender of the U.S. competitive advantage in attracting the best and brightest global talent in fields like AI and engineering.
Precisely. We would lose the talent pool at the source. And for U.S. employers, that talent pipeline, it just becomes completely unpredictable. Companies that rely on that stable 3-year window to integrate and vet their graduating foreign-born STEM students would be forced to scramble for other, often much faster and more expensive, visa pathways. Or potentially just move their R&D roles to countries with more stable immigration infrastructure.
Now, this issue is highly contentious. The policy debates have been raging over the program's economic impact. What are the core arguments from the critics who want to see this program restricted?
Well, the critics, and we have voices cited by our researchers on this, they often describe OPT as functioning as a cheap labor pipeline for big business.
Okay.
Their argument centers on the idea that the program is exploited to staff positions that could be filled by U.S. workers, and that the employment often goes way beyond practical training and becomes long-term staffing, which they claim depresses wages.
So they're calling for severe limits or even outright elimination.
That's their position.
On the other side of the debate, what do the empirical economic studies say about OPT's role in the broader economy?
The empirical research, by and large, disputes that wage suppression argument. Studies show that the program has not been significantly linked to broad displacement or wage depression for U.S. workers.
So what do they say it does?
Instead, these experts argue that the talent pool is complementary. It drives innovation and increases overall economic activity. And restricting this pipeline, they argue, risks a measurable economic deceleration.
Our legal team noted some analyses that cited some really staggering economic consequences if this pipeline were to be severely restricted.
The potential loss is significant. Restricting OPT could lead to a measurable decline in innovation outputs. Fewer patents filed, slower growth in high-demand sectors like biotech and semiconductors, and fewer new startups being created. Some economic analyses that were cited suggest the long-term lost output could be equivalent to the annual GDP of a significant mid-sized state.
Wow! So this program is actually vital economic infrastructure.
It is. And this threat of elimination, it also opens the door to powerful legal challenges based on something called reliance interests.
Reliance interests. What does that mean in this context?
This is a key legal tool that university systems and industry groups are already preparing. They argue that abrupt, fundamental changes to OPT undermine the settled expectations and the massive investments that all the stakeholders have made.
I see.
Students entered U.S. programs and paid tuition under the current rules, relying on that OPT option for their career. Institutions built their entire international recruitment and academic programs around this stability. Legal challenges would argue that undermining these reliance interests with abrupt regulation is, in legal terms, arbitrary and capricious.
So given all of this acute uncertainty, the need for contingency planning for any current or prospective F1 student has never been higher.
Absolutely. The time to examine your visa alternatives, to rigorously document every aspect of your practical training, and to align your career mobility with specific hard expiration dates is now. You have to assume the policy runway could shorten and plan accordingly.
It reminds me of an analogy from attorney Chris Ingram. He said, the OPT pathway has served as a runway for STEM talent. If that runway is shortened, you still need to land, but you'll have less glide path.
That perfectly illustrates the urgency of planning ahead in this shifting regulatory horizon.
So as we bring all of these stories together, Katalin Karikó's incredible perseverance, the tightening grip of digital vetting, the complex modernization of the H-1B, and this profound uncertainty around the OPT system, the picture becomes pretty clear. The U.S. innovation ecosystem is fundamentally delicate, it's dynamic, and right now it's navigating a period of intense policy turbulence.
And the big takeaway for STEM professionals is that your career path is now shaped just as much by your skill as it is by the ability of the U.S. government to adjudicate your status. It's shaped by automated systems looking at your digital history and by policy proposals that can just change your future without warning.
The immigration process isn't just about filling out forms anymore.
No, it's about managing a continuous risk profile.
And we keep coming back to this core finding from our legal research. Immigration policy is infrastructure.
It is the absolute bedrock upon which the entire U.S. technological enterprise is built. And when that foundation shifts, whether it's the beneficiary-centric lottery cleaning up fraud or the uncertainty threatening to collapse the OPT program, the entire structure has to adjust.
The universities recruiting PhDs, the startups planning their product cycles.
All of it. They have to immediately and painfully adjust.
Yet we have to balance that policy turbulence with the constant, unwavering drive of STEM talent, the kind of drive we saw with Karikó refusing to give up for decades.
That's the other side of the coin. Talent will always find a way to contribute, even when it's faced with huge policy hurdles. So this moment, it's really an invitation to clarity and preparation, not a signal to retreat.
So for you, the listener, navigating this landscape successfully, it requires a clear strategy. And based on the research from our legal team, we've got 3 key takeaways to help guide your planning.
First, be digitally intentional. You have to assume your digital footprint travels with you and that it's subject to automated review. While you should absolutely defend the principle of lawful screening that respects context, you have to govern your online presence with the awareness that these high-stakes decisions are being made based on signals from imperfect tools. Your digital history is now part of your professional risk assessment.
Okay, that's number 1. Number 2 is plan for contingency. The era of stable, guaranteed immigration pathways is, at least for now, over. You have to anticipate continued regulatory changes, especially around OPT and H-1B. Align your career strategy with multiple possibilities. Know your visa alternatives, understand the maximum duration of that new cap gap protection, and set aggressive planning timelines well before any status expiration.
And third, document your value aggressively. Policy and regulations, they can increase the complexity of your journey, but they cannot cancel the impact of your contribution. Your strongest defense against all this uncertainty is the demonstrable, undeniable value of your work, your patents, your publications, your unique contributions to your field. That concrete value is the constant that policy shifts can't erase.
This detailed discussion we've had about the H-1B overhaul, the OPT threat, the algorithmic vetting, it shows that the rules governing how talent moves are now decisive in the global contest for technological superiority. And that leads us to our final thought.
The future of U.S. innovation really hinges on a single question. How will the U.S. decide to manage its talent infrastructure in the next 2 years? Whether it successfully stabilizes that study-to-work pipeline and ensures the lawful treatment of highly skilled applicants, or whether it allows the foundation to fracture from uncertainty and arbitrary enforcement, that choice will determine its competitive edge for the next decade.
It's an issue of global leadership.
Absolutely.
And as attorney Chris Ingram reminds us in summing up this crucial moment, policies change, but the purpose remains: to build lives, build careers, and build a future worth striving for. The more clearly we see the landscape, the more confidently we can move through it. Thank you so much for being with us today. We hope you gained a lot from this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, helping us build this community together. Also, follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team. We would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing this material for our presentation. See you next time on Let's Talk U.S. Immigration.
Yeah.
Bye for now.